All right.
Tell me when the recording starts.
Yeah, and it's begun, and the court having returned from recess, we will now be hearing oral arguments from um, the now arrived representative of the defense on behalf of the United Nations. Um, Mr. Hausen may begin.
Thank you, Mr. Chief Arbitrator. Good evening, Mr. Chief Arbitrator Red and the Permanent Court for Arbitration. I apologise for the tardiness on my behalf in uptaking the defence and the time it has taken in order to do so. I'd like to begin my introductory speech today that in your hands, Mr. Chief Arbitrator, lays the foundation of what the United Nations becomes. Never before has such an outrageous and outlandish event happened in the entire long-standing and peaceful history of the United Nations, of which the Permanent Court of Arbitration has a long-standing attachment to. I am sure the court will appreciate if I keep my speech succinct and accurate, much unlike my learned friend. Firstly, the defence of the United Nations suggests concerning the legal issues presented to the Permanent Court of Arbitration for review that there is indeed a necessity for the United Nations to have a provision in its charter in order for member states to leave. This, as the well-known predecessor of the United Nations, the League of Nations, had such a provision written into its founding constitution, in its founding document. The United Nations explicitly left this out. It was left out for a reason, so that member states could not leave. We believe that despite Indonesia leaving, it was a mutual agreement. It was an agreement of the member state and the United Nations. We believe that such precedent is required again. The precedent wasn't that a nation or member state could leave. The precedent was that both the United Nations and the member state mutually agreed. If we use the evidence submitted by the aggrieved, we will see that is the Secretary General in his letter accepts the withdrawal of Indonesia. As we have stated as the United Nations, we have not accepted the withdrawal of ABISTAN. Furthermore, other issues which we would like to address is whether the United Nations has a treaty with ABISTAN. We state this does not matter. A treaty is not needed for accession to the United Nations. For example, we have the case of Bhutan. Bhutan has no treaty with the United Nations for it to join. It never has had a treaty, and there's no current treaty. Therefore, the argument that ABISTAN needs a treaty is ridiculous, as they are not exempt. We believe that our issues, the other issue, the second issue, was addressed in my previous comments, that the United Nations can indeed prevent a member state from leaving the United Nations, as discussed with the matter between Indonesia and the Secretary General of the United Nations. We do not reject the facts surrounding the case. We do instead argue the interpretation of law is what is the matter of hand here. We argue that we have taken legal and adequate steps in order to provide the correct solution that ABISTAN cannot leave the United Nations because we simply do not want them to leave the United Nations. And that in itself is indeed enough. Thank you, Mr. Chief Arbitrator Red.
Thank you, Mr. Hausen. Um, so, may I clarify here for the understanding of the court that the argument of the defense is that no member state of the United Nations cannot unilaterally rescind their membership without the consent of the United Nations, um, uh, and as well as the fact that the treaty, the part that the aggrieved has brought up, the part of treaties binding membership between the member state and the United Nations, that, for example, in Bhutan's case, no treaty affirming their membership was needed to affirm their membership in the United Nations anyway, then if I may ask, what does affirm membership in the United Nations if there would be no treaty to do so?
Thank you, Chief Arbitrator. I believe you're right in interpreting that our argument is that we cannot prevent, that we can prevent ABISTAN from leaving, that we can indeed, that there is indeed a necessity for both parties to be agreeing in the withdrawal of a member state. Furthermore, if it pleases the court, I did forget indeed to mention that we would like to submit more, well, not evidence, but supporting factors to our arguments. If it pleases the court, I am willing to send such links and such documents over to support this, and I'll explain this in the format of me passing it over and its relevancy. But sorry, to get to your final question, what is needed? I have to confess that this was overlooked during the formation of the United Nations. That the process of joining was only accepted. So I believe, please do not make this law. It's by no means set in stone. That's what I'm trying to say. It's not set in stone. But the common themes behind accession to the United Nations by member states is a desire to join the United Nations. So this can be an executive stating we're joining the United Nations, such as Bhutan did, because the nature of Bhutan was an absolute monarchy. Of course, no longer is Bhutan an absolute monarchy, but it was the powers of the king or the head of state who exercised this, and no treaty was needed to be made. And then it was the United Nations who then accepted and ratified their entrance. And I argue, the United Nations and the defence argues that such a request was made when ABISTAN joined the international body and did not, throughout the ongoing process, explicitly state, or I'm led to believe that they did not explicitly state they did not want to join the United Nations. I believe there's a long window of process when they wanted to, ascend into the international community, and they did not explicitly state that they don't join the United Nations. It was only later, after a vote was about to be hosted. I believe, if I'm to whittle it down and boil it down, I apologise for my long-windedness, that ABISTAN completed its request to join the United Nations simply by stating that they wanted to join the international body, which is the United Nations.
So, if I may make this clear, what you are saying is that with Abistan's previous desire to be involved in the international body, the international body as you define is in itself the United Nations, as well as the fact that Abistan made no effort to refute the recognition of any other nation, or refute the recognition of the whole entire international community before even being put to a vote in the United Nations. Is that what you're saying?
Essentially, yes, Chief Arbitrator. I would also like to mention that I would not dare to take upon myself the whole entire United Nations, agreeing that we are the sole international body and international community, but de facto that is the case. There are no alternatives. Most countries which are sovereign, most states which are sovereign and recognised as sovereign, are members of the United Nations. I would also like to just clarify that, if that's okay with you, Chief Arbitrator.
Right. And, however, might I add that the head of state of Abistan never implicitly nor explicitly affirmed, as I would presume the Abistan to be a autocratic state, that they never affirmed, that the head of state of Abistan never affirmed any membership status to the United Nations, as you use an argument in favor of Bhutan, which you say, for Bhutan's case, the head of state of Bhutan explicitly said and declared and proclaimed that if Bhutan were to become part of the United Nations, even without any existing treaty to do so, yet it would seem that that case does not exist for ABISTAN, wouldn't you say?
Indeed, I would say that they are by no means a clone or replication. I was only stating that there need be no treaty in the case of Bhutan. I would like to suggest that there's no need for an explicit. I would suggest there's no need for an explicit mention by heads of states or even by treaties they want to join the United Nations. I would say that it's an implied term.
So the implication comes from, it doesn't have, what you're saying is that there has to be no explicit proclamation. It can also be implicit. That's what you're saying.
Yeah. Yes. That is what I'm saying. Thank you, Chief Arbitrator.
Right. Okay. Well, if there is nothing else to be brought up, unless by the court to see the documents as you said were to be provided by the defense, if you don't mind.
Yes, it'll be a pleasure. Your Honor, just allow me to get it up. I also would like to request I am allowed to send the transcripts and dates of which events had happened, like to add to the facts of the case, if that is permitted by the court.
Granted.
Thank you, Chief Arbitrator. Mr. Chief Arbitrator, which channel am I placing the evidence in? Is it into direct messages with you? Or
if you could send it, yes, into my DMs, please, that'd be greatly appreciated.
It'll be a pleasure to slide into your DMs, Chief Arbitrator.
Thank you, Mr. Howson. And if there's, if it's just that, then very well. But if there's anything else, please do send it now.
Yeah, sorry, I'm just getting the links ready from the ABISTAN.
Right.
I'm also amending my comments, the first evidence submitted or first fact submitted. I'd also like to reaffirm we in our first point in the introductory speech, we are reusing the evidence that was submitted by the aggrieved. However, we simply request that you see this with an impartial light and see it from an objective stance. So therefore, it's our evidence as well as their evidence.
Right.
For the letter between Indonesian Secretary General. But I believe that is everything. Would you like to have the Bhutanese Would you like evidence for the Bhutanese?
Yes, that as well.
Okay.
Just so that's still fresh in my mind. Right. Well, thank you.
It's a pleasure, Chief Arbitrator. If I can clarify anything, or if my learned friend from the aggrieved can clarify anything, please feel free to message either him or I respectively. I believe he will be fully cooperative, Mr. Jelik. Oh, Mr. Jelik shall. Chief Arbitrator, thank you.
Right. Well, considering that oral arguments have been concluded by both the aggrieved and the defense, the court will now move to deliberation and um, whether or not to affirm in our opinion either the aggrieved or the defense. For now, we'll be adjourned. Thank you.
Thank you.